Common law is probably one of the most misunderstood phrases in the Constitution. It occurs in the Bill of Rights in Amendment number 7, which has to do with what we infer are civil suits. And it actually maps very neatly to the concept that is advanced earlier in the text of the Constitution, referring in Article 3 about the judiciary to the judicial power which shall extend to all cases in law and equity. Equity means fairness. And so, common law court would be a court that convenes to hear a matter of equity, a matter of, hey, someone alleges that there has been something unfair that has happened. Now, you can't have laws writing every possible thing that's unfair that could have happened. And so that is the realm of a common law court. And common law, of course, it's an unwritten law largely, but it's just the minds of the people in a locale. A lot of scholars and judges in particular have misinterpreted common law to mean uh, what they call case law. In other words, the past opinions of judges. But the opinions of judges really are just opinions. They aren't a law of any form. In fact, the moment you even say that, you're attempting to push onto the judicial decision system the powers of the legislature, right? Legislating from the bench, right? That's a huge problem. So there is in reality no such thing as case law per se. It is not a law. It doesn't have the weight of law. It's just a corpus of opinions, and you could draw from that as part of your corpus for your institutional knowledge to say this is part of the fluff and stuff that makes up what our common law system is. But there's actually a huge hazard that we often fall into, and the judges in particular in our country tend to push us into, and that is that this misunderstanding that the American common law is necessarily the same as English common law. There are elements that were preserved with the break between the United States and Great Britain. There were elements of the English judicial system that we held on to, like the presumption of innocence and so on. But there were elements that we also emphatically rejected. And a lot of those elements are outlined in the Declaration of Independence. And so it would be horribly erroneous for us to say that everything that is intended when the founding fathers say common law was just a carbon copy of whatever they were doing in England at the time, because no, they were trying to separate themselves from that system. So I think it's very worthwhile to understand what was the ethic of the founding fathers, what this common law thing means. There's actually some really great exposition in the Journal of Discourses about what common law means. And so if we really want to understand that in depth, no, we can't go with the theory that it's just this medieval English monarchical standard.